Because the court is satisfied, the rules and guidelines applied in each of the disputed areas are reasonable and a correct interpretation of the underlying early absentee voting laws. The certification of the results of the 2020 Wisconsin presidential election after the Dane County and Milwaukee County recounts is affirmed. The certified results show Joseph Biden and Kamala Harris received 1,630,866 votes, and Donald Trump and Michael Pence received 1,610,184 votes, a difference or margin of victory of 20,682 votes in favor of Biden and Harris. The determination of the court is that the petitioner appellants here have not demonstrated that an erroneous interpretation of Wisconsin early voting laws happened here. But I just wanted to make some summary comments with regard to where the basic disputes arose. The first was approximately 5,500 ballots that had defective or missing witness addresses. 687-6D was interpreted, or 6D provides that a clerk may return a ballot to a voter under those circumstances. It's not mandatory, but the clerk can do so. It's not an exclusive remedy. In 2015, the Wisconsin Elections Commission set down guidance for clerks to use to look at various sources to remedy or cure an incomplete or missing witness address. We're not dealing with signatures of voters or signatures of witnesses, simply an address of a witness which was required so that if there were issues of validity, the witness could be contacted. The statute is silent with regard to what the commission can do in curing a defect in a ballot. It certainly does not prohibit the clerks from doing so. Adding the requisite information by the clerk has been in effect since before the 2016 election, the election which Trump prevailed in Wisconsin, I believe after a recount. It's long-standing. I believe it's not prohibited by law, and it is therefore a reasonable interpretation to make sure, as the court indicated earlier, that the will of the electors, the voters, are brought to fruition. The second broad category where there is an issue that involves approximately 170,000 ballots in the two counties is the claim by the petitioner's appellants that there was no written application for a ballot. We're dealing with 686-1 AR of the statutes. More than 10 years ago, the administrative agency in charge of election law developed Form EL-122. It's entitled Official Absentee Ballot Application / Certification. They've been in use continuously in elections since that time. It came into effect after the 2008 election with regard to early absentee voting in order to streamline the process. Many methods for obtaining a ballot are authorized under the law. There can be an online application, the website, My Vote. There can be regular mail application, email application, or in-person application. Whenever in-person application is used, Form EL-122 is used, and as was indicated on its face, It is designated official absentee ballot application certification. The only thing that happened after the 2008 election and the adoption of EL 122 is that two steps were combined into one on the form. It's been in continuous use since then, and I believe it is a correct, allowable interpretation and application of 6861 AR. The third area in dispute is the indefinitely confined issue under 687 2 and 4. It affects approximately 28,000 votes. This statute's been in effect for more than 30 years. It allows voters to self-identify as qualifying as indefinitely confined. There is no proof needed. You don't need a doctor's excuse. An issue rose here in the spring when the Dane County Clerk apparently made Facebook postings implying that because of the Safer at Home orders in effect, anyone could use this particular section in order to early vote. The problem is that this section does not require the voter ID requirements that are applicable in other sections. The Republican Party immediately sued for injunctive relief. The case was Jefferson versus Dane County, 2020, appellate, I believe 557. As a consequence of that litigation, the commission established guidance indicating that it is the individual choice of the elector to utilize that section, that it should not be used to avoid voter ID requirements. And the language in that guidance essentially was approved by the Wisconsin Supreme Court. I recognize that litigation is ongoing, but to infer that people utilized and voted under that section to evade the voter ID requirements is no basis for not counting those votes. It's far more likely, because of the ongoing pandemic, that people were very concerned, especially those with compromised systems, to go out in public, to not want to stand in line for potentially hours at a polling place in order to cast a ballot. I certainly could not strike those ballots based on an inference which is not really supported in law, or supported in fact. The last category in dispute, amounting to approximately 17,000 votes, are the democracy in the park provisions. Petitioners' appellants argue that 6.855 applies and that this was an inappropriate or improper interpretation of law, creating a clerk's office for voting. I believe the correct application is 687 4B1, the governing provisions relating to drop boxes or the ability to deposit a vote with the clerk. Those drop box provisions, again, have been in use and were used around the state. The distinction here being a potential voter could not obtain a ballot at any such location. It's not an extension of the clerk's office for voting. It is simply an extension to allow a voter to deliver a completed ballot in a socially distanced way. It certainly is an appropriate and correct interpretation of law to allow that to happen. Because the court has determined that there has been no reliance on an erroneous interpretation of Wisconsin's early voting absentee laws, I indicated I enter judgment in favor of the respondents, the court will issue an order confirming the results as I've indicated, the certification that I've indicated earlier.